Good afternoon, everyone. Sorry, we have a bit of a technical difficulty. Somehow or another, the videos, I'm the only one that the videos are working, but the team are working in the background. But we're going to get cracking anyway. So online, myself and then Advocate Fritz Beekers from Ambassador Trust. It's a pleasure having him here today. We're going to talk about wills and just the intricacies around wills and estate planning. And the interesting stat that we saw last year coming from the Marshal of the High Court in Pretoria is that only 1 in 6 people have a valid will currently that was registered last year at the master when they passed away. So which means 5 out of 6 people do not have a will. It means that if you sit in a room and you have 5 friends with you and you have a will, statistically, none of your 5 other friends have a will. And it's a major concern. And obviously this month being Wills Month, it's important for us to put some spotlights on that and make sure we help you guys. So for that, I have Fritz with us today to discuss this. Fritz, he's been doing this for more than 30 years, I think, probably on estate planning wills. So he understands this industry. So thanks for your time, Fritz.
Thank you, Stian. It's an honor.
So Fritz, while we jumping into it, I'm going to ask you a few questions, and I think the first thing is, and maybe with your expertise of seeing probably thousands of people when it comes to estate planning, wills and trusts and stuff like that, why do you think it is the case that so few people have a will?
I think people just don't spend the time of day on it. I don't think they understand the seriousness of having a will and versus not having a will. I think the majority of people underestimate their own longevity, and they think there's always another time to do it. And the problem with wills generally is that by the time that you need the will, you're probably not mentally or physically in a position to draft that will. So we quite often find that people would be diagnosed with a terminal illness, and during that time, they simply do not have the capacity to draft a valid will. So I think there's 2 points of importance here, the one being having a will and the second one having a valid will. So just in terms of the statistics in South Africa in general terms, it's said that around 70% of all South Africans in the working class do not have wills. That means that about 3 out of 10 people that earns an active salary actually have a will. The problem with the statistics at the Master's Office refer to the validity of wills, which means that those wills that are being lodged have a majority error factor. It means that the majority of those wills that are lodged are not valid. So firstly, we start with about 30% of the working class having wills, and then we sit with about 1 in 6 individuals dying with a valid will. So it's quite horrendous to look at the statistics.
Sure. So okay, so let's get into this step by step. Just unpack it a little bit. What's the difference between having a will in South Africa or revoking a will or having a will offshore? Should you have international wills? So just let's dive into that a little bit.
I think the first important part for a South African resident is that if you draft a will in South Africa and you revoke all wills, it implies that your South African will be relevant to all your assets, whether they locally or abroad. So when you draft a will for your South African assets and you also own assets abroad, it's quite critical to separate those 2 wills from one another. Whether they are movable or immovable assets doesn't matter. So it's important that when you have assets offshore, that you have a separate document drafted. Of course, an offshore will that can be drafted locally for purposes of those assets. So a lot of people are confused when it comes to offshore assets. They believe that they have to go to the actual jurisdiction, have an attorney in that country draft the offshore will, and only then will the will be valid. That's not correct. So you can draft a will in South Africa for your offshore assets. It's just quite critical that you mention this will is relevant to my assets in New Zealand, for example, or in the UK. When you draft a South African will, another factor of importance is when you revoke your previous wills, is to limit that revocation to South African assets only. So we would find that someone may have assets in Gibraltar or in the Isle of Man. They've drafted the will quite a couple of years ago. There's no reason for that will to be changed. And then they'll go and change their local will by saying, I revoke all previous wills and codicils made by me, which implies that also offshore wills are revoked by that will. So when you redraft or update your local will, make sure that you're only referring to your South African assets and not your assets abroad. So it's two separate documents. It's possible then that you may have a multitude of wills pertaining to assets in various jurisdictions abroad. Two important factors is that all your movable assets will form part of your South African value for purposes of estate costs, and your immovable assets would form part of the offshore jurisdiction. So for example, if I own a property in the UK, that property will be transferred through the deeds office in the UK and also pay estate costs in the UK. But the household content would form part of my South African inventory, which means that from an estate duty point of view, I will pay the estate duty on my local assets, on my local liquidation account as far as those movable assets are concerned.
So, okay, so no, I don't think a lot of people in the audience will have international assets, but for those that do, that was really, really relevant. Thank you. So now the next question is, let's get to the intricacies of a will. The first one is the aspects of a will. So the first one is beneficiaries. So in a nutshell, who's your beneficiary on your will?
Okay, so it's important to separate between two groups of people who can benefit. The one called heirs and the other one called beneficiaries. So the true terminology means an heir would be someone who inherits from a will or from a deceased estate, and a beneficiary would be somebody who benefits from a policy on the life of the deceased, or benefits from a trust that was created by the deceased or any other third party. So for purposes of a will, we will refer to you as an heir or your heirs if you draft your own will. So it's important that when you draft a will, to differentiate your heirs into two groups. The first group being those who are financially dependent upon you, which will start with a spouse and of course include minor children. And the second group might be third-party heirs. So if you haven't taken care of the requirements of your dependents, your estate will receive a claim at the time of death, where those people would request an actuarial claim to support their needs. So we quite often find that people would draft a will listing all sorts of special bequests to third parties, and then just say, and the residue to my spouse. When we do a calculation of that estate before death, we quite often find that the residue is either zero or that it's not supporting the spouse's claim, which means that your legacies, your special bequests, will not prevail. So it's important to do a proper analysis to ensure that your dependent heirs are taken care of before you look at third-party heirs. As far as beneficiaries are concerned, we can either create beneficiaries in a living arrangement. For example, I could have a living trust and nominate my spouse and children as beneficiaries, but I can also create a testamentary trust and nominate beneficiaries who will benefit from that testamentary trust. The only other list of beneficiaries is those that will benefit from your life policies and investments. And the last group of beneficiaries we call nominees, are those individuals nominated to benefit from your pension fund schemes and retirement annuities. They are not called beneficiaries or heirs, but rather nominees. And the reason for that is that we can nominate someone, but they might not necessarily receive the benefits. So what that means is, while an heir and a beneficiary would normally receive the benefits you aim to get to them, a nominee is merely nominated to receive the benefits, but there are still certain boxes that needs to be ticked. For example, if I die before retirement and the trustees of my retirement fund see that I've nominated my secretary as the beneficiary of that fund, they might say that she's not financially dependent upon me and therefore she will not receive 1 cent out of that pension fund. They will first then take 12 months' time to determine actual dependence of the deceased, and only thereafter, if they find that there are no dependents, will they take into consideration the nomination of third parties? So those are the three categories: heirs, beneficiaries, and nominees.
So, Fritz, the summary out of this, what I take out of this, it's really important that you make sure that your estate planning or your financial planning is properly set up so that you can ensure cash flow is properly secured for those three different segments of your estate or your dependents.
Yes, definitely. I think the two most important characteristics of a good will is one that takes both liquidity and continuity into consideration. So when you draft the proper will, from a liquidity perspective, you know you've got money to fund certain costs, and I'll talk about that in a moment. And you know that the ownership of those assets can continue in the hands of the heirs, beneficiaries, or nominees. So the first one being liquidity or liquidity planning refers to three categories. And in order of priority, always the need for cash to cover all third-party debt. That means bonds, finance, credit arrangements, surety signed, which is the first category and receives preferential treatment at the time of death. The second category being estate costs, and we will always start with the executor's fee as a preferential estate cost and then move down to estate duty, capital gains tax, and third-party expenses. And the third category of liquidity is taking care of dependents, ensuring that my wife can stay in the house that we bought together, that she can afford the rates and taxes, and that my children can continue to be in the schools that I've put them in and eat the food that they used to. So the three categories of liquidity is debt, estate costs, and taking care of dependents or my household budget. On the continuity side of the will, it refers to, in the event of me saying, I bequeath my entire estate to my spouse, we sometimes do not take into consideration that my spouse may not be the person who can continue with those assets. She's not a businesswoman. She's not a farmer. She doesn't have the necessary skill to do crop spraying if that's the business I was in. So it's important to understand that certain assets can only continue if I have a specific individual identified to continue with that asset. So there's two options there. The one being that my son is also a farmer. Therefore, I can bequeath the farm to my son on the condition that he will take care of my spouse. But there's also a second option where both my wife and I decide that in the event of my death, I will bequeath the farm to her and she will appoint someone to run the farm on her behalf. If those options are a possibility, we will investigate both. Sometimes I'm a partner in a business where it's not possible for me to nominate my spouse as a succeeding heir or succeeding shareholder. My partners are not interested to make my wife a co-shareholder of my crop spraying business, so they would insist that I'm bought out at the time of death. So certain assets in the estate need a little bit more attention than normal property, shares, and cash. They need the attention where I have to make a decision whether it's possible to continue with that ownership or whether I should rather include that list of assets on the liquidity side of the estate. So then, in the event of death, I have a written agreement already in place with my partners. I've secured the price for those shares, and I will be forced, as a result of my death, to sell those shares to my living or surviving partners. They, on the other hand, would be obliged to pay me for those shares or shareholding, and it would form part of the liquidity portion of my estate. And my executor can use the funds or the proceeds from those sales to fund third-party debt, estate costs, or taking care of my dependents.
So, Fred, while you're on that point, is there any stories, I think specifically one of the relevant aspects where we see this really becomes relevant is, as you mentioned, in the farming community or people with businesses. Is there a story that comes to mind that you can share that say, this is what's happened where if the guy did proper planning, it might have turned out differently?
Yeah, unfortunately, I have a long list of horrendous stories, and I'm not going to share them all today because I will keep you busy with that. But I think what jumps to mind is on both sides, both on the liquidity and continuity side. various stories that I've been involved with. One particular story that comes of mind was a very successful farm in Mpumalanga, where I met the father. He died. It was considered afterwards that it might even have been suicide during a difficult time. But the fact is, it was never formally noted that he committed suicide. Yet he died, and he bequeathed his estate to his 4 sons to run the farm, which consisted of various categories, and they would each manage their portfolio of assets in the farm for the benefit of themselves, but also for the benefit of the farm company as a whole. What they did not consider was the fact that, firstly, there was insufficient liquidity to cover the exposure of that farm. So the bonds were not taken care of, which meant that we had to pledge some of those assets as security to incur further debt as a result of certain expenses not being paid. There was no funding for estate duty because the initial will that was drafted bequeathed everything to the spouse, and at that point in time, there would have been no need for estate duty. And the final will that the father drafted was one where he decided rather to give the farms or the company that owned these farms to his 4 sons, not taking into consideration that the moment he changed that will, the liquidity analysis changed entirely. While he was still entitled to receive a spouse's deferral on taxes, all of that was forfeited, and he only qualified for the first portion of the estate duty abatement. And very quickly, that structure was illiquid. Within 4 years of his death, that whole company came to an end. It was liquidated. There's nothing of those assets left for the family, and they've all split up, and they're all angry at one another, feeling that it was the other one's responsibility to solve it. From a continuity perspective, I quite often see that people disregard the interests of their own children. So I quite often see that someone would bequeath their business interests to their children in equal portions, not knowing that that's exactly what they did drafting the will. The will would read something like, in the event of my death, I bequeath my entire estate to my 3 children in equal portions, not taking into consideration that only one of the children is involved in the farm or is involved in the business. The moment the father does that, the other 2 children becomes party to that business, and they're of the opinion that they're only going to receive some sort of a passive income. They're going to receive dividends at the end of the year without working because they're not part of the working environment of that business. Quite often, within months after death, that business is either deregistered and started from scratch, meaning that they try to resolve the existing company and transfer its assets to the child that continues with the business and trying to pay out the other siblings. But 9 out of 10 times, the problem that we sit with there is that the non-participant heirs will not sign surety for the exposure of that business. So they're not prepared to sign sureties for input costs on the farm. They're not prepared to be exposed to the service level agreements with existing employees. They're not prepared to arrange for new finance for the replacement or maintenance of certain assets. And very quickly, that entity or business cannot continue to be managed properly. So without giving any names to that, both of those sides on liquidity and continuity, unfortunately, is the majority rule. Funny enough, in South Africa, more than 76% of estates are illiquid. That means that less than 3 out of every 10 estates that are being administered have sufficient cash to bury the person who died and fund the estate costs, which means that in more than 76% of all deceased estates, we will sell assets. If we sell assets in the event of death, we always receive a lot less than market value for those assets, and very quickly the estate is worth a lot less than what the heirs thought it was. So that's the problem when we sit with illiquid estates.
So Fritz, maybe there's one of the people in the audience, attendees, really good question, but I want to ask this question in relation to some of the other stuff that's applicable. So when it comes to minor children, and this specific attendee says, single parent with a minor child of 5 years old and full custodial rights, considering in a will. So in a portion of a will, one of the things that's important when there's a beneficiary or an heir that is a minor, there's certain things that you need to take into consideration, i.e. trustees, guardians, and maybe a testamentary trust. Would you please allude on that and answer that question while alluding to those aspects as well?
Yes, I think it's a very good question, because it's quite common in South Africa that households break up for various reasons, of which a deceased partner is one of those scenarios, where a surviving spouse would continue to take care of their minor children, and of course also divorce. I think that the important part of this question is that we sit with a minor heir who can't inherit. So because the way our Administration Act works in South Africa says that in the event of a person receiving an inheritance and he is of less than 18 years old, he's a minor, his inheritance must be guarded by a guardian or go to the guardian's fund. If a guardian is not nominated in that will, that inheritance will automatically go to the guardian's fund. I don't want to go into the detail of the guardian's fund. I just want to summarize that it's the last place you want your inheritance to vest. Why? Because not only does it offer very little growth or proceeds on that inheritance, even in the event where it's fully cash. The problem is that when we transfer that inheritance at the age of 18 to your child, that child has absolutely zero financial intelligence, and they will typically sit on the street within a couple of months or years after that event, not knowing what they could have done differently. So they are not ready or prepared to manage that portfolio of funds. We can only look at pensioners in South Africa to understand this problem. People not knowing how to work with money at the age of 65, receiving their pensions all at once, and within a couple of years, they're back in the working environment because they cannot work with that lump sum value. So how much more would we not try and protect a minor child? So the guardian's fund is not the solution. So for this particular parent, I would advise to make use of a testamentary trust at least, and rather place the minor's estate value in that trust. In terms of the composition of assets, it's quite important to understand that we would typically advise the executor to rather liquidate the assets that's part of that estate. The reason for that being that it's very difficult to manage a portfolio of business interests, vehicles, household content, and even certain immovable properties on behalf of that minor child. So we would rather argue that they should liquidate as much of those assets as possible, rather invest it in an interest-bearing facility that offers at least inflation or more growth, and make the transfer date, if you are going to add a transfer date of capital, not less than 25. It means that that child can only receive the capital, not the income, the capital that was bequeathed to him or her at the age of 25 or later. I can promise you that even the age of 25 is not enough for most children, but at least we've taken them to an age where they, at this point in time, should have some sort of a tertiary education. So they should be a little bit more equipped. I think what's also important about this is that my choice of trustees should be very relevant under the circumstances, not just to appoint the first names that jump to mind. I think the first important thing about trustees is, yes, you need to trust them. But unfortunately, when you die and you've nominated your siblings or your friends as the trustees of that trust, they quite often find themselves in a position where they can no longer differentiate between the assets of the trust and the assets of the personal estate. And those assets become intertwined. And by the time that the child reaches the age of 18 or 25 or 30, whatever the capital distribution date is, we cannot identify those assets any longer. So we would always insist that the will requests the services of an independent trustee with your nominees to ensure that the normal statutory requirements are abided by, and that the trust is managed in a way that we can secure the inheritance up until at least the age of capital distribution.
Fritz, just a quick note from Wendy. They say if you can try to play, put your video on. Yeah, there we go.
Thank you.
Cool. Cool.
Just
Thanks,
on that
Wendy.
same
Really
question,
appreciate it.
on that same
Yes.
question, and just quickly add, you also asked the question with regards to guardian. And can I just mention there that the nomination of a guardian is very critical in any will, whether you are a single parent or not. So we would always advise someone to nominate a guardian in the event of a failing natural guardian. So the question came from an individual. We wouldn't know whether the natural guardian is still alive. Sometimes the natural guardian is not a suitable guardian. So it might happen that I was married to a person who we got divorced, and that individual is not competent to be a parent. So under those circumstances, I would rather nominate a guardian, failing the natural guardian, to be appointed by the family members on behalf of this child. Fortunately, when we create a trust, we are under no obligation to transfer any of the value of that trust to the natural guardian, which means the inheritance is protected. But quite often, the guardian is a capable person, and we would then say in the will that the trustees would transfer to the guardian of this minor child such portion of income that's required to educate that child, maintain them, and pay for their basic needs, up until the point where that child can also be nominated as a trustee or receive the capital distribution. So always make provision for a guardian nomination, even under conditions where the natural guardian is still alive.
Fritz, on a testamentary trust, now, what does a testamentary trust cost anything for an individual to draft?
Okay, so there are different ways of creating testamentary trusts. The two common ways is to draft the trust deed while you're still alive and add that trust deed that's not registered yet to your will. And a lot of clients prefer that method. It is more expensive, but then I can see the full mandate. I can see what instructions are given to the trustees, what are their authorities, what are their duties, etc. And I have a slightly better feeling of what a trust is after death. But the trust is not registered yet. It will only be registered at the time of death. The second option that we can choose is to provide in the will for the executor and heir or any guardian of an heir, in the event where that heir is a minor, to choose to receive the inheritance in a trust. That's a different form of testamentary trust. What that implies is that it is possible for an executor to say, listen, the individual receiving the inheritance might be an adult dependent. He's still a student at the age of 22. It is my suggestion that we create a trust for this individual and receive his or her inheritance in that trust. That will become a living trust created by the executor, and it will be managed very similar to a testamentary trust up until the point where that minor child or adult dependent, or sometimes even an insolvent or sequestrated heir, where their personal circumstances have improved. So the testamentary trust itself does not cost money, unless we're talking about the drafting fee of that document, where you prefer to rather see the full mandate. But where the costs come in with the testamentary trust is at the time of death. So when the person dies, that trust still needs to be registered. It's not a trust document that we then lodge with the master's office. It is the will with all ancillary documents attached to the will. For example, if I drafted the trust mandate while I was still alive, I will lodge the will and that mandate. If I didn't draft the mandate and I provided for a trust to be created after death, I only lodge the will. The master will then receive the trustee acceptances by those nominees, the individuals that I've nominated to act as trustees after my death, and they will be appointed by the master in terms of a letter of authority. And the letter of authority is the effective date from which those trustees can act on behalf of that trust. So the problem that we have with testamentary trusts is that they are not in existence at the time when you die. So it means you die tomorrow, there will at least be another 6 to 10 months after death where no trust will be available, which means that we've got a duration of time where we need to provide for the month-to-month funding of that individual to ensure that his school fees are taken care of and maintenance, etc. So we are in favor of living trusts a lot more than testamentary trusts, but they cost a lot more. So while a testamentary trust may cost nothing before death, a living trust will incur a fee. And those fees can run from, I don't want to mention real numbers, but they will cost somewhere between 5,000 and 15,000 rand, depending on who you're using for those services. So it is costly to register a trust, and there's also maintenance costs on that trust. We need to submit tax returns, administration requirements. There's a banking facility that requires funding or costs. So it's important to understand that it's not a cheap option to draft a trust while you're still alive. But the benefit of drafting a trust while you're still alive is that you can start using that trust. And one of the biggest benefits of a living trust is that it can start to receive some of your assets while you're still alive, even for your own benefit. So for example, if I'd like to invest a portion of my income, and the portion I'd like to invest is less than 100,000 per individual per year, I can make use of my annual donations limit. So what that means is the receiver says you can donate up to 100,000 Rand per individual per year without paying donations tax. Now, it's quite critical that we don't get confused with income tax. It's not an income tax deduction. It means that it's after-tax remuneration or benefits that I've received during the year that I may donate to my living trust without incurring an additional tax of 20% donations tax. So we would typically find with younger people where they'd like to start an investment portfolio that they can donate within the 100,000 limit. Their savings might be 3,000 Rand per month or 5,000 Rand per month, and they'd like to start with a solid estate plan. So the benefit of making your trust the owner of those investments, it creates the foundation, the very foundation that at some point will benefit you directly, whether you are in a position of insolvency, divorce, or death. Those assets will be protected against that incident. So if I only died with that trust, it means that the trust assets are excluded from my estate costs. So I don't incur estate duty of 20% or capital gains tax of 18% or executors charges of 3.5% plus VAT or any other third-party expenses related to my trust assets if it was managed correctly. And for a lot of people with a 40-year economic term, if you think about 25 to 65 earning a remuneration, that becomes a substantial portfolio of wealth that you can create over time in that entity. So just to put that in perspective, the Buckingham Palace has been in trust for more than 400 years. It means that when the Queen died last year, Charles literally just walked over the platform to Buckingham Palace with his pillow, I would presume, and no transfer occurred in the deeds office. There was no clearance for estate duty or capital gains tax. There was no attorney fees to transfer any assets into his name. He's merely a user of those assets. And the same will continue with his offspring and their descendants. So what it means is we can create a generation skipping device through a trust mechanism. It's not merely a trust that's registered for your family's benefit. It can become a generation skipping device and create a legacy. Most people are aware of Anton Rupert's estate plan in South Africa. He was considered to be one of the wealthiest individuals in the South African history. Funny enough, I would disagree and saying he was probably one of the poorest individuals in South Africa because he died with less than 2.7 million Rand in his estate when he died around 2006. And the reason for that was he created all of his wealth, and just to put that in perspective, more than $7.9 billion in the Anton Rupert Family Trust. So what that means is that he was not the owner of that wealth. He was actually a poor individual, but he knew the principles of estate planning, and he created his wealth from the word go in his trust. So by the time Johan Rupert took over, we had a 100% secured continuity model. It meant that there was no risk that those companies would dissolve, and there was a zero risk for liquidity as far as estate costs was concerned, because he died with an asset value of less than the estate duty abatement. Most nursery teachers will die with an estate larger than the estate duty abatement. It means that the majority of people will incur those taxes because they don't understand the basic principles of estate planning. So I'm not saying that a trust is relevant to every individual, but I am saying that where it is relevant, it might be the better solution or the better alternative compared to a testamentary trust.
Fritz, so just stepping about a little bit, one of the questions that came about is also executives. A lot of people like to nominate their friends or family as an executor or a child or something like that. What's the pros and cons when appointing an executor, and also would the master of the High Court accept that executor, etc., etc.?
That's a long list of questions that you actually raised, Tian, and I'll explain why. The first thing is that if we talk about the pros and cons of nominating executors, there's two groups of executor appointments. The one being people whom I know and trust, my spouse, children, siblings, my heirs, my parents, etc., or a friend. And then there's the professional group of executors where we nominate our accounting officers or attorneys or the insurance company or the bank as an executor. And we've heard horror stories on both of those sides. So it's unfortunately not true that when you nominate an executor in one of those two categories that you are secured to have a simple estate administration process. So let's start with the pros first. The pros of nominating on both sides. If you nominate somebody whom you know and trust, we can assume that that person would negotiate a cost on your behalf, even though the executor's charge is not the larger estate cost. It's still up to 3.5% plus VAT of the estate. And then we have not even mentioned any costs that are incurred after death, because the executor is also entitled to receive 6% of income that's generated after death for the period of administering that estate. So if you're a wealthy businessman and you generate a lot of profits in your industry or your farm, there's still a far bigger fee that will be paid if you haven't taken that into consideration. So nominating somebody whom you trust is quite critical in the event where you expect that person to negotiate costs on your behalf. What that means is it wouldn't make sense just to nominate your son or your brother or your parents as the executor or executors, because they might not even know that that's the way they need to negotiate. So unfortunately, the majority of those estates are not administered in the correct way. They merely go to an accounting officer in town or an attorney, and they are exposed to the normal threats of estate administration, and I include costs with that. The second category of let's call them professional executors, the cons on that side is, I mean, everybody's heard where the bank was involved administering an estate or an insurance company or a large corporate, and you were just a number on their books. You couldn't contact someone. You didn't know who worked with the estate. You struggled for weeks and months on end to get feedback from them because they didn't know who's working with the estate, etc. So unfortunately, in larger corporations, we quite often find that they don't have good networking systems and they don't have designated individuals who take control or responsibility for the estates. So on the con side, I think there's a lot of cons on both. But my opinion on the appointment of executorship is one where I say you either know the person and you know that they are capable of doing this. So it's either someone whom I know and can also either administer the estate or negotiate the fee on my behalf. If I don't have such a person in my network, I would rather appoint a professional institution or corporate. I would rather appoint even the bank under those conditions, a corporate institution to say, please be the executor of my estate and ensure that my estate is administered properly. What we provide for on most will options, and it's the same with the NMG option, is that you can nominate a joint executor. And that's probably the ideal, where I nominate both my spouse and a corporate that's a professional industry or linked or with the correct network to administer this estate successfully. In that way, my spouse or my sibling or my child has direct access to that file with the master's office, and they can see exactly what's going on. They're not left out in the dark. So it's a very clever appointment, but I can just mention that the co-executor will not participate in the actual administration process. So it's because they cannot do that. Your question is whether the master would appoint that person. You're quite right in saying that firstly, it's a very good question, is that the master will not just nominate or appoint a nominee as an executor. And the reason for that is they are not prepared to try and teach you how to administer the estate. They don't have the time for that. The assistants cannot spend the time to assist you to complete the forms correctly or follow the procedures correctly. They will simply insist that you appoint an attorney or a qualified auditor to, it's in terms of the old Section 9(1) of the Estate Administration Act, with you to administer that estate on your behalf. And then they'll issue that letters of executorship in your name together with the other person as co-executor. Quite often under those circumstances, we would just advise the clients to stand off, rather transfer that executorship to their nominee, the person that they've nominated them to administer the estate, and stand back, because they will just withhold the process or extend the term of administration. So the biggest threats that we find with this estate administration is term and costs. Term being that when someone contacts my office and say, listen, my father died or my spouse died, they would quite often say, and she died last year, July. And I'll say, and how far are you with the estate administration process? And they'll say, no, they've done nothing. I say, but have you reported this estate? You had 21 days to do that. No, they haven't. They have not even reported this estate. Have you paid over the estate duty, because you only have 12 months before you start incurring debt and interest? Oh, no, they haven't done that either. So obviously, they are incurring additional costs that could have been avoided entirely had they just appointed a professional individual or corporate to facilitate that service. So the unfortunate part is that the majority of people cannot facilitate the administration within the term that's required by law. From a cost point of view, yes, it's very true that some estates will drag out for years to come. It's not always and quite regularly not the fault of the executor. We quite often see that people have difficult estates to administer. They insist that the firearms be bequeathed to their minor son. That minor son has no competency certificate. That whole process drags out the estate administration process, and we wait years on end to try and finalize this estate. The number one reason for not finalizing estates is liquidity. It means that there's simply not funding to pay the outstanding credit arrangements or to fund the estate costs. In South Africa, it quite often happens that the heirs will stand in for those expenses in a pro rata ratio, meaning in the ratio that they inherit from the estate. Each one of those heirs will then contribute towards the larger estate account, and we often find that they just don't have the means to fund those costs. In South Africa, when we talk about estate costs, people always think about estate duty, capital gains tax, executors' charges, and just let me tell you, I'm just referring to burial costs. We can't bury that person. They don't have the 18,000 Rand to bury him or have a proper cremation service. So I'm not referring to large sums. People simply don't spend any time on liquidity planning when they draft wills.
Fritz, this comes to one of the questions that's asked. I think you've answered the question in terms of estate expenses and capital gains tax, that it's advisable to have a policy to cover stuff like that if you haven't done proper planning. One of the other questions that came about, I know there's, without mentioning names, there's one or two companies out there that currently sells indemnity products and say, no, we cover all your expenses and stuff like that. I feel that's a slippery slope and a dangerous place to be at. But I think it's important to just discuss that and versus a normal life policy and the costs and fees associated with that. What is your opinion on that?
Yeah, I don't want to give too much comment on the first part of your question, but I am going to say that the policy or policies that you're referring to in terms of indemnity, my biggest concern with those policies is that they do not pay out to the deceased estate or to a beneficiary of the deceased. They pay out directly towards those companies. So those policies are firstly taken out for the benefit of the company where you facilitate that service. Yes, they do offer certain benefits on that product, that you are covered up to a certain percentage of estate costs, and that's also within certain perimeters and requirements, that should your estate exceed the value that they calculated that policy on, you will still incur the normal fees. My opinion on that is that if you spend a little bit of time on your own education and just understand why and what for you need policies and how they are structured, it's actually quite simple, rather just to insure it yourself by way of a normal standard life policy. And I want to mention this, a normal life policy and not a telephone product. I'm not in favor of telephone products that are only underwritten at the time of claim, because 9 out of 10 times all the information was not shared at the time when those policies were issued. So the best kind of life policies are those that are fully underwritten. It means that they are both underwritten for your medical conditions and financial ability to fund them. And your chances of a valid claim is extremely high on those policies. There are certain restrictions, for example, the suicide rule that says that if you commit suicide within a 2-year term after issuing that policy, they have the right not to make payment. So if you're aware of those limitations and you understand the basic principles of life cover, you are definitely far better off by taking out normal life insurance. I want to mention 3 things on life insurance. The first thing is that life insurance is probably, if you are healthy and insurable, the only and most cost-effective way of securing cash. And I'll explain why I'm saying this. There's only 3 ways of finding cash if you die. The one would be a life policy, which was taken out on your life. It means that you were the life assured. It doesn't help that you were the owner on another person's life, because that policy does not pay out when you die. So the first thing is that a life policy is the cheapest and probably you've got the highest success rate of covering the exact expense. The second way of finding money is through finance mechanisms, and it's literally the second cheapest alternative. And it's already 10 times more expensive if you go for the cheapest form of finance. And what we know for a fact is that you're not going to qualify for the cheapest form of finance at the time when you need it. You're probably going to go for a personal loan, which is one of the more expensive routes, or you're going to go to a loan shark and find yourself in a very uncomfortable position. So finance arrangements start by being at least 10 times more expensive than insurance. And the third level is liquidating assets. And that's unfortunately the norm. So in South Africa, like I mentioned earlier, more than 76% of estates are illiquid. And don't confuse that with insolvent. Insolvent means your assets are worth less than your liabilities. I'm referring to solvent estates, but they don't have sufficient liquidity. For example, I own a farm or a property, but I don't have the cash to fund the mere estate costs related to the transfer of that property or the bond that needs to be settled at the time of death. So if you liquidate an asset, the 2 greatest concerns there is firstly that you're going to forfeit the asset probably at far less than market value. So if we had a chance to sell it at market value, we might still have received a fair portion or a fair and reasonable return on that asset. But we quite often find that those assets are sold on execution auctions, and the people who would make an offer at that auction is not prepared to pay market price. You're probably going to pay at least 10% agents' commissions over and above the loss. So you might end up, if you're lucky, with between 50 to 60% of a fair and reasonable market value. So that's the first great concern. The second concern of liquidating assets is that you lose the asset. And if you lose the asset, you also forfeit all the benefits that that asset provided. For example, if I have to sell your second property, we also forfeit the rental income. If I have to liquidate your investments, we also forfeit the interest you received. If I have to sell your share portfolio, we also forfeit the dividends you received or could have received on those shares. So liquidating assets is by far the most expensive way of securing cash at the time of death. The 3 kinds of policies that I'd like to refer to quickly, just for purposes of liquidity planning, is policies that are designed for debt, policies that are designed for estate costs, and policies that are designed to take care of your dependents. If you know a little bit about insurance, or you educated properly by your financial advisor, they will explain to you that there are different premium patterns attached to policies. And without going into any technical portion of this, is that some policies premiums would escalate far rapidly than others. It means that I will be in a position of not being able to afford my policies within a very short period of time. And the reason why a lot of policies are structured like that is because someone might convince you to take a policy because it looks like it's a cheap policy, but they're not explaining the premium pattern. We never want an aggressive premium pattern attached to a policy that's designed for estate costs or taking care of dependents. The reason for that is that that's a policy that we would like to fund whole of life. It means that it's going to be paid until the day you die. You want a premium pattern that you can afford for the rest of your life. But when you look at debt, sometimes we've got short-term debt, 5-year term personal loan, 10-year term commercial loan, 20-year term bond on properties. Now it's a different story, because if I'm only needing this policy to cover the exposure for a 5 or a 10-year term, of course you can take out a more aggressive premium pattern product. It means that you will pay a lot less over the term, and you will probably cancel the policy if you survive the term. So we don't have a problem if you take out more aggressive premium patterns on shorter term products. So for example, if I'd like to cover a debt for a 3 to 10-year term, your premium pattern may be aggressive. But the moment you pass the 10-year term mark, you'd start becoming a little bit more conservative, all the way where you might rather go for a level term premium and say, I'd rather go for a low premium or low premium pattern to secure the payment of this policy, because I will need it at the time of death. When we look at those 3 levels of policies, you'll find that the first category, being the ones that's designed for debt, may be ceded towards your creditors. You can cede that policy, and in the event of death, it will pay out to them, and they by law obliged to pay over any balance of that policy that's above the outstanding debt, and it will be paid back to the estate. The second category is the estate policies. Those are the policies that's designed for the executor to fund estate costs. The executor needs to be able to have access to that money in the estate. It means nothing if it's paid to a beneficiary and the beneficiary runs off with the money. Or the second spouse simply says, listen, it's not my problem that the sons from the first marriage inherited the farm. I'm not going to pay their estate duty. So those policies, we would typically want to be paid over to the estate or the heirs who receive the benefits under those assets. And the last category is the dependents. And that's where we would like the dependents to receive the benefits as quickly as possible. We don't want them to wait 2 years for the estate to be finalized. So we would typically want those policies to have a beneficiary nomination on them so that it can pay out within weeks after your death, whether that is paid to your trust to take care of your dependents, or whether it pays out directly to your spouse or children to take care of their immediate needs. So the purpose of those beneficiary nominations is then to pay for your rates and taxes, your accommodation, your typical life expenses. So if you understand the basic principles of those 3 categories, it's by far a lot better choice to take out a normal whole of life policy. Be the owner, be the premium payer, and understand the rules around those policies. A last thing I want to mention on liquidity planning is to keep it relevant. Every year that passes, your circumstances will change. Your debt might be more or less. Your children might be older, or you might have a newborn. And in terms of estate costs, you might have done no estate planning through the last year, which means that your estate costs have increased because your assets are worth more in a year's time. Or you may have implemented some sort of an estate plan or estate structure, and your estate costs are in fact a lot less. So in all those circumstances, your liquidity portfolio should be revised. The last thing you want to do is keep on paying for a life policy that you do not need. You must remember that the only way you can receive the benefits from a life policy is through death. You have to die to get it. So it's a grudge purchase. We would much rather want you to contribute towards your own retirement than funding life policies for which you need to die. So a death policy is a critical part of estate planning, but it should also be calculated correctly and maintained to keep its relevance.
Fritz, we have another 4 or 5 minutes. There's 2 questions that came about, so let's see if we can answer these 2. The first one is, please elaborate on the major problems that cause wills to be classified invalid by the Master's Office. So if we can answer that in a minute and a half.
Okay, the 2 most common factors there is the person didn't sign his own will. You cannot believe how many people have died without signing their own wills, or they've only signed the last page. So a will has to be signed by the testator or the testatrix. And the second reason is that it's not witnessed properly. it means that the witness is either the spouse or the heir of this person who is disqualified as a witness, or it's not witnessed at all. Under all of the circumstances where a will does not qualify or doesn't tick the boxes of the 1953 Wills Act, those wills will either be considered null and void, and your previous will become the relevant will to be administered. And the unfortunate part about older wills is you might have been married to a different person at that point in time, or it might still be your vasty girlfriend who receives your inheritance. So it becomes an irrelevant will. And of course, on the other side, it's important to understand that if your will is going to the court, meaning where the heirs insist that this be the valid will, the master will insist that the court issues an order to make that will a valid one. So it has happened in South Africa that an instruction that was sent to a financial advisor was considered a valid will, even though it was not signed by the testator or even witnessed, because it was proven that the application was sent from the client's own computer, and that it was discussed at a meeting where notes were made regarding that will. And the courts accepted the circumstances under the conditions. But the problem with that, even that order, is that it was a very expensive court case. So we don't want to incur those additional costs. So rather just make sure that you comply with the basic requirements. So those are the two basic requirements.
And then last question, Home Affairs have registered my mother as married instead of widowed. So we're waiting for them to amend their death certificate. Now, we see that often currently in this current situation. And we've notified the executors. What expenses will the estate be liable for due to the protraction?
Stian, just confirm your question again, because I don't want to elaborate too much on that. Just say again, what's your exact question?
What expenses will the estate be liable due to the protraction?
Because of the fact that my mom has not been classified as a widow yet.
And a delay has taken place.
Okay, so the unfortunate part is that the estate will carry all the consequences and costs associated with that poor administration. And it happens quite regularly, as you mentioned, that government institutions do not do their part. So the important part is that you would, because I would assume that that's the question, is you'd still have to administer the first estate. For example, if my father died, are we talking about the mother's will here, or are we talking about my will?
Yes. Mother's will.
Yes. So both my parents had wills. My father died, but my mom was not yet shown as a widow. My father's will has to be administered first. Only once it's finalized can they start with my mom's will. So that's what's going to happen under those circumstances. Had she been noted as a widow, we could have started with this will administration immediately. But quite often, depending on the father's will, the mother will inherit from the father if she died after a 90-day period. So most wills provide for a 90-day term where in the event of a person dying within the 90-day terms, is disregarded as an heir, and we continue with the succeeding heirs. If you pass the 90-day mark or whatever term was provided for in the will, then you'll have to wait out that full first administration term.
Cool. So, last thing, there's one other question I'm going to ask this individual talking about the implication for putting an actual mother that it's a bit of a longer-winded question. I don't think we're going to get to that now, so they can email us and we can help with that. But in it being Wills Month, I think we need to launch, and I just put in on the webinar chat. You guys will see a website, nmgwills.co.za. NMG, in association with the Ambassador Trust, which is Fritz's company, have launched a company or a system called NMG Wills, where you can, within 5 to 7 minutes, with the information that you have now, I think some equipment has taken place, and I want to suggest everyone, as a complimentary on everyone that attended this webinar, you can go in there, you can register free of charge, complimentary. You can draft yourself a will. If you in the code section, just type in the code NMG, and you can download a valid will and get it signed. There is some instructions on how and who and how to do that as well, to make sure that your will is valid. And then you can assist us, and if you want to, you can print out 2 copies, and we can also store that copy for you on safe storage. So I think that's about it. Is there anything else on that you want to add, Fritz?
Yes, I want to add to the fact that if you draft your own will, can I please suggest that you do discuss this with your financial advisor, so that you know that you've got the funds to administer that estate. So please don't just draft the will. Also discuss it with one of the NMG advisors, that you know that you are covered in the event of death. You can administer that estate.
Yes, yes. And then one last question. Yes, this session has been recorded. So we will make it available on social media platforms as well as through NMG. So if anyone wants a copy of this, they're more than welcome to ask for it. So thank you everyone for joining. Thank you, Fritz, for your valuable time. Really appreciate it. And I think it was a really, really insightful session.
Thank you, Stian. It was a privilege.